Good morning. Please be seated. We are here for oral argument in cause number TX 170004, Hees et al. Versus Maricopa County. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs. We have discussed in conference this case. At this point, you may proceed, counsel.
Good morning, Your Honors. I am Tori Beardsley, and I represent the appellants Carrie Hees and Richard Zielinski. Before I begin, I would like to request leave of the court to reserve 5 minutes for rebuttal.
And we will leave that up to you.
Thank you. One simple way to resolve this case is to understand that there is a distinction between a valuation or a classification issue and all other issues. This distinction, for the purpose of appealing a claim for the county assessor, is true both in fact and in the drafting and organization of Arizona Revised Statutes Title 42. A valuation claim or a legal classification claim is defined by the statute section 42-16251E and includes things such as a mistake in the property description, clerical or typographical errors, non-existence of the property or existence of the property on the valuation date, destroyed property, or any error that does not require the use of discretion. This is the opposite of what we have here in this case. Here we have what's called the tax rate issue.
Counsel, could I ask you a question?
Yes.
Assuming we accept your argument, then what would be the time to serve a complaint under Article 6?
My understanding is that the rules of civil procedure would then apply, and it would be a year.
So 10 days if it's under Article 5, but a year under Article 6?
Yes, and my understanding of the difference is that under the statutory scheme, a valuation claim or a legal classification claim, you can appeal directly from the assessor's decision under Article 5 to the court. And for all other claims, there is a specific process set forth where, in this case, for example, we've litigated this for 2 years before appealing to the court. And so the county had 2 years of notice of what our claims were, what our general arguments were, and that's my understanding for the differences in the statutes as they're written.
Well, if we're looking at trying to harmonize statutes, why would we say the legislature intended a 10-day provision under one and a year under the second? It doesn't seem, we're talking, you couldn't get more extreme, could you?
Well, I believe for the reasons that I just explained that the Title 42 consistently makes this distinction and creates a separate process under Article 5 and Article 6.
Isn't that just a process that creates the right to appeal? And once there's an appeal, aren't they both tax appeals?
Yes, they are both tax appeals, but I believe that they are treated differently.
Why?
Because, I'm not certain of the legislature's intent and why they made this distinction. All I know is that if you look at the statutory scheme, it appears that the legislature has intentionally made this distinction. And
They intentionally distinguish between kinds of claims. So when we talk about notice and service and all of those things, those are more procedural, agreed?
yes,
And
they
when we talk about procedural issues, part of the reason for the short timeframes is to ensure that the county knows what their budget will be moving forward. So when we talk about this kind of a claim in the context of a tax court, not a regular civil claim, how do you differentiate between these claims, and the need for the county to know what their budget will be going forward, what claims are out there, how they mitigate any claims within the budgetary year?
Because that concern is cured by the fact that there is this appeals process set forth in Section 6 that's required for things such as a tax rate appeal. So with a tax rate appeal, you have to go through this whole process that gives the county notice of what your claims are, that you're going forward with a claim, what the potential differences in tax rates are going to be. And in this case is a perfect example where the county had 2 years of notice of the appellant's claims and were well prepared to litigate that. And also...
But I think that misses the point that Judge Campbell was raising, is that 10 days, the county would know within 10 days on whether or not there's going to be an appeal from a tax assessment. Under your theory, under Article 6, on an error correction, they wouldn't know whether there's going to be appeal for that for up to a year, right?
Yes, that's true, but I think that the reason why the 10-day notice is necessary is because on a valuation claim, you aren't required to go through that appeals process that I've just exhausted. And so then it becomes more important for the county to have notice that you're going to be filing this claim, or that you have filed with this claim. And also, the court in... excuse me.
While you're looking for that, let me ask you a quick question. You talk about the county having notice in the 10-day time period for a certain group of claims, and a year is what you're suggesting for the other group of claims, correct?
Yes.
And when we talk about notice, if we talk about it specifically in context of your case, first your client served the assessor, and is that when they were on notice in your mind?
Yes, and I think that if
we take that as when they were on, quote, notice, that would be counter to the statute that says you've served the wrong party, correct?
Well, let me back up a little bit. I think that in terms of notice of, in the informal sense of generally what our claim is that we're going to appeal and what the dollar amount would be to address those concerns that you discussed about budget, et cetera, the county actually had notice when we filed our original appeal with the State Board of Equalization back in, I believe it was 2014.
So when we talk about notice versus service, do you see those as two separate things, or do you see them as the same thing? If somebody has notice, then service isn't required?
I do think that they are two separate things, but I think that that is kind of where we come around to, well, this appears to be an excusable neglect case. The statute, as I have talked about a little bit, seems to call out specifically, and if you look at Article 5, each provision, for one reason or another, calls out valuation and classification claims. It does not call out additional claims. In other parts of the statute, for example, 42-16-251E, it makes a distinction and calls out both types of claims into separate categories. And 42-16-168 does the same thing. And this is important because it is very reasonable to understand that an attorney doing his due diligence would look at these claims and say, okay, the legislature has set up these two separate processes, has set up these two separate categories, and has intentionally created a different process. And in the brief, defendants talk about how allegedly the law is well settled in this area, and the court actually relies on the same cases that defendants do, which were the Elman, Maricopa County, E.C. Garcia, and Pecoria cases. And if you look at those cases, each one of those cases, the appellants clearly admit that it's either a valuation or a classification case. And that's not the case here. There's actually no case law on point here to determine whether or not the provisions of Article 5 apply to a non-valuation or classification case. And thus, it was an abuse of discretion of the tax court to look at these cases that don't even speak to this issue that we're concerned about here, about whether or not there's a distinction, and find that there was no excusable neglect.
Isn't it just as reasonable for the tax court to look at those cases and think, okay, they're not directly on point, but we're going to follow the maxims that are set forth in these cases in all tax cases?
Respectfully, I disagree, Your Honor. I think that when the central issue to this case is there a difference between valuation and classification, and whether or not these Article 5 provisions apply to a non-valuation and classification case, you have to look at another tax rate appeals case or some other case that doesn't fall into the category of valuation or classification, and the tax court did not do that.
When you applied to when you first filed notice with, and it was, you had a hearing before the SBOE, weren't you told that you needed to serve the Board of Supervisors?
Yes, and that was...
And you were told that the assessor was a non-juror entity, correct?
Yes, Your Honor, that's correct.
So how can then you turn around and say, oh, it's excusable neglect when we filed a complaint in the Superior Court that we did the same thing we were told we couldn't do in the SBOE?
Because I think if you read the face of the statute, it is understandable that an attorney who has done his due diligence would make such a mistake. And
so between the SBOE and the Superior Court, the assessor became a juror entity that could be sued?
no, Your Honor, that was a mistake.
And is that an excusable neglect? Or is it just lawyer didn't learn from their first mistake?
Truthfully, I think I would consider that caption error excusable neglect. It was a clerical error. It was a mistake and a misunderstanding of the law on our part.
Clerical error on who we sue? I mean, don't we? That just seems a little odd to me that it's clerical error on who we actually bring a complaint against.
Well, when you look at the entities, it is a little confusing. And if you look at Elman, the court has held previously in Elman that for the purposes of identity, issue and identification, that the county assessor's office and the county itself are one and the same for issues of tax rate appeals. And that, and the Elman court found there that, yes, appellants did serve the wrong entity. They should have served the juror entity, but it was excusable neglect that they served the wrong entity, because for the purposes of issue notice and identification, the two entities were the same.
Once that case is out there, is it excusable neglect for the next set of attorneys to make that same mistake?
Yes, I do think that it's still excusable neglect for the reasons I stated earlier about the fact that Elman is not quite on point, and we really proceeded not understanding that Article 5 applied to a non-valuation and classification case.
I would think a reasonable attorney who is reading this record or reading the case law would understand that the assessor is a non-juror entity. Wouldn't you agree with me? I mean, do any of these cases say, oh, the assessor can be sued under limited circumstances?
No, they do not.
So a reasonable attorney looks at this and knows, I need to serve somebody besides the assessor, right?
I do not agree, respectfully. I think that it's reasonable if you read the face of the statute. It is reasonable to understand that there's a different process put forth for these types of cases. It does not direct you to look back at Article 5, and perhaps had the legislature included language in the applicable provisions of Article 6 that instructed the attorney to go back to Article 5, and then this issue would be cured. But the law is not that clear, and there is no case law that's directly on point to this issue.
Well, what about Falcon X-Ray Sandoval versus Maricopa County? Holds that the Board of Supervisors is a proper entity to serve under Rule 4.1.
In any case, I believe that the correct remedy is to allow the party to go back and serve the correct entity, especially in a case such as this, where the jural entity does have notice and is prepared to defend these claims instead of dismissing the case.
If we talk about this instead in the context of notice of claim statutes, you blow your 180 days, your claim is gone, it expires. And it seems very harsh, but it also serves the purpose of allowing a governmental entity to be able to budget, which is very important, you would agree, that a government entity knows how much money they're dealing with. So how is this different? If you don't serve within a proper time frame, if you serve the wrong party, et cetera, why is this not drop dead? Why is this excusable neglect?
I believe for the reasons that I stated previously, that there was notice. It's the same attorneys representing the assessor's office that appeared now as appeared previously. In terms of substance, the notice is there. And so to construe this statute in a way that prevents the appellant from proceeding and correcting what amounts to a large error in taxation and assessment, instead of using the statute as it's intended, which is to simplify the appeals process, does a great disservice to the statutory scheme and to the taxpayers. I have nothing further.
Would you like to reserve?
Yes, please. Thank you.
Thank you.
Good morning, and may it please the Court. My name is Joe Branco on behalf of Defendant Appellee, Maricopa County. Appellee Maricopa County respectfully requests that this Court affirm the tax court's decision that the appellant taxpayer's appeal abated. First, in violation of Section 42-16209A, the appellant taxpayers failed to name and serve Maricopa County within the statutory 10-day window.
Let's talk about the 10-day window.
Yes, Your Honor.
We have an argument that Title VI and Title V should be read independently, and that 10 days doesn't necessarily apply to claims brought under Title VI, that they're different in substance as well as procedure. Can you address that point specifically?
Yes, Your Honor. That is the crux of this appeal. And simply put, there is nothing in the legislative history, the legislative intent, that indicates that when you've got a property tax appeal, you've got Article 6 appeals over here, you've got all the other appeals over here, and never the two shall meet. There is but one area within Chapter 16 that provides a process for perfecting an appeal. That happens to be in Article 5. Article 5 is entitled Property Tax Appeal to Court. And although that's not dispositive of the issue of whether or not another procedure might apply, of course nothing would stop the legislature from pointing to a different chapter, a different article, a different set of statutes. In fact, the legislature does that in a different area of the tax code that involves property tax appeals. Under Section 42-11005, it's the third type of property tax appeal that hasn't been discussed today regarding illegality. It actually refers back to Chapter 16 and specifically to Article 5. But in this case, what we have, and you can derive it from whether it's the context of these statutes grouped together under Chapter 16 and dealing with the same subject matter, property tax appeals. And I think that in terms of context, it's important to recognize that we are dealing here with ad valorem taxation. This idea that error correction is over here and value is over here, and again, just like the procedure, never the two shall meet, that's impossible. The error correction appeal statute itself, the definitional statute at the beginning, 251, and I'm sure it's not going to confuse the court, but when I was trying to get up to speed on this, it would confuse me sometimes when people just use the last three digits. So when I'm saying 251, I do mean 16251. It refers not only to error correction in the abstract, but also intrinsically related to valuation. It wouldn't do a taxpayer any good to go out, get the assessor to correct an error, or take it up to the state board or even to the tax court to correct an error if it didn't ultimately reflect a change in the valuation. There would be no refund. There would be no purpose to doing that, to simply have a piece of paper in the assessor's office that now is correct. The idea that you can separate entirely valuation from error correction is false. And not only legally, in terms of the statutory scheme, whether we're talking about 252, 254, 251, all of which are the error correction statutes. When we look in this particular case at appellant's claim, whether it's their notice of claim letter that referenced property value, valuation, the assessor's supposed and alleged errors in valuing, whether we look at the notice of appeal that was misnomered a petition before the tax court, 17 times they discuss property value, the valuation of property. That's what counts 1 and 2 are. And by the way, what count 3 discusses is an equal protection type of issue related to classification, that people with similarly classified properties were not being treated similarly. And so overall, the legislative intent indicates that the procedures that happen to be found in Article 5 apply equally to property tax appeals, whether that is a valuation claim or whether that is an error correction claim. And more specifically, when we're looking at the suite of statutes that occupy Section 207, 208, and 209, and of course what's at issue here is 209, they are a little bit more broad even than, for instance, 203 or 201, because they're not relating specifically to valuation claims. They say relating to valuation. And again, when you're dealing with ad valorem taxation, it's inextricable. It's baked into the cake here. And one thing that caught me during the opening argument today was this idea that each provision of Article 5 calls out valuation. Even if this court was to conclude that in some way the legislature had intended to put up this firewall between 6 and 5, or 6 and the valuation claims, the problem is that this particular statute that we're looking at, Section 42-16209, doesn't actually reference valuation itself. Now, it's the county's position that it would be incorrect to read 207, 208, and 209 separately from one another, but even accepting part of appellant's claims, 209 would still apply. It doesn't discuss valuation in particular. Further, in the absence of following the process under 207, 208, and 209, appellants have attempted to substitute the civil rules, and specifically Rule 4, and that fails for 2 reasons. Number one, there's nothing indicating in 254 that the legislature wanted to point litigants, taxpayers, or the assessor to the civil rules. Where would you find that? It's actually in Section 209. It says that you will serve in the manner of the civil rules. And Rule 4 by itself can't apply, because Rule 4, and specifically because we're talking about serving a government entity, Rule 4.1, discusses the service of pleadings. And it refers itself to Rule 7, and Rule 7 does not acknowledge an appeal or a notice of appeal as pleadings. Those would be things like complaints, answers, the things that we know kick off and respond to a lawsuit. And so there is nothing in the legislative intent that indicates that even if Article 5, or the suite of statutes that are located in Article 5 don't apply, that automatically a litigant would jump to Rule 4.
Counsel, I'm going to change the subject here for a minute, and I'm sorry if I've ruined your train of thought, but just procedurally, when they filed a notice of claim originally, or they filed a claim and they were before the SBOE, didn't the county alert the taxpayers that they had served the wrong person?
No,
the
Your
wrong
Honor.
entity?
No, Your Honor, the county did not. And that's part of the problem with the administrative record in this case, and reflecting on what is supposed to happen under 254, and specifically 254A, 1 versus 3. When this initial notice of claim is filed, this letter is filed, this is not like a notice of claim under 821, although that was referenced in the letter. Notice of claim is a term of art under 254 that kicks off the administrative review. Under 254A, it either goes to, for the purposes of this, it would either go to the assessors first, or it would go to the county. But the proceedings are not, and adversarial might be the wrong word, but it's the best one I've got now. It's not adversarial between the county if it's under 254A3, as it should have been initially and later was corrected. It's not adversarial between the county and the taxpayer. It's adversarial between the tax officer and the taxpayer. The county is not a tax officer. Under 251, tax officer is either the county assessor, the county treasurer, or the department. And so the problem with saying wasn't the county on notice, the county was on notice for 2 years, that isn't technically correct. And even if it was, it doesn't get around the idea that you still have to serve someone with a notice of appeal. Otherwise, they don't know you've appealed. In this case, you
lost me a little bit, because I thought the county attorney represented all of the entities that you just referenced.
They do, Your Honor.
So the county attorney is representing let's say with the assessor, and they get the original notice, correct?
Yes, Your Honor.
Okay. And then at some point in time, didn't the county attorney in the SBOE say you didn't serve the board, you only served the assessor?
Yes, Your Honor. In the record, and I believe it is one of the attachments to the index of record at 37, there's an assessor's letter. It's actually from the assessor rather than from the county attorney's office. But it's from the assessor. It's a November 26, 2014 letter that lists a number of reasons why the initial notice of claim was deficient. Among those reasons, aside from failing to use the proper form, which is statutorily required, and other things, it does state that there is an issue with following 254A because they followed 254A1 and filed the notice of claim with the assessor rather than 254A3 filing it with the county. The taxpayers had the opportunity.
The county, you mean the Board of Supervisors?
Correct, Your Honor. Okay. I apologize. And so at that point, the appellants appealed the assessor's decision to the State Board of Equalization, which is not, as the briefing sometimes appears to do, a county entity. It's not a county board. And so they appealed that decision to the State Board. The State Board said, we don't have jurisdiction to hear this because you didn't follow the proper procedure. Appellants at that point had the opportunity to appeal a decision of the State Board of Equalization. For whatever reason, they chose not to do it. It's not in the record of why. They went back, as they've noted, and filed what they called an amended notice of claim under 254A3.
With the board?
Correct.
And at that point in time, they did notify the Board of Supervisors?
Correct.
Okay. But the interesting thing, one of the interesting things for me in this case is the fact that the county attorney, it was the same county attorney, deputy county attorney, that represented the different entities that we've discussed, the Board of Supervisors and the assessor, correct? He or she was aware that this notice had been filed, had alerted someone to the fact that it was improperly filed, and that it was amended and filed correctly. Am I stating that correct?
I think that our position would be that you don't amend the notice of claim, you've simply filed a new one, and I don't.
Fine, that to me is
Understood, Your Honor.
okay. So they filed a new claim,
Yes.
properly addressing the board at that point, the Board of Supervisors at that point, right?
Yes, Your Honor.
Okay, so then they move to they then go to the the Superior Court. We're still on the same page?
Yes, Your Honor.
Is the same deputy county attorney representing the Board of Supervisors and the assessor at that time?
I want to be cautious, Your Honor, because at one point there was a different set of attorneys in the administrative level. So I think at the assessor level there was one set of attorneys, at the State Board of Equalization and at the tax court, I believe that was the same deputy county attorney, yes.
So from the State Board to the tax court is the same lawyers?
For the assessor, yes, Your Honor.
For the assessor, what about the Board of Supervisors?
At that point, Your Honor, under 254, the board or the county, which should properly be, the county, as the juror entity, is not a party. And that's why I was saying before.
Because they had not been served.
No, Your Honor.
We're talking now the tax court.
Apologies, Your Honor. They should have been a party at the tax court, but they were not a party because they had not been served, nor had they been named at that point.
But at the board level, they were represented by the same deputy county attorney.
No, Your Honor, because it's my understanding at the board level, they are not a party to the administrative proceedings.
The Board of Supervisors?
Correct, Your Honor, because under 251, it discusses a tax officer, and the tax officer is defined as county treasurer, county assessor, or department, not county, not Board of Supervisors. And so then when you turn to the proceedings under 254, the purpose of involving the county, particularly when you have a tax rate, is that, providing the notice of claim to the county when you've got a tax rate is because they're the ones that are ultimately setting the tax rate. But they're not a party to that proceeding. The tax officer and the taxpayer are. And so the county can be thought of as a conduit of information for getting that notice of claim to the proper.
You're talking about the SBOE.
I'm talking about prior to that at the.
That's not what I'm talking about. I'm talking about the SBOE.
Understood, Your Honor. And under the statutory scheme under 254, it simply says the parties.
And those parties would be?
The assessor and the taxpayer. Properly speaking, in this case, it would be the assessor and the taxpayer. More generally speaking, it's the tax officer and the taxpayer.
Okay. So at that point in time, the Board of Supervisors were not a party to the SBOE proceedings.
That's my understanding, Your Honor. And there's nothing that I've seen in the record that indicates that the county was represented before the board, the state board.
Okay. So then when when the taxpayers filed in the tax court, they only gave notice to the county assessor.
Yes, Your Honor. Yes, Your Honor. And Ellman makes clear that for purposes of relation back under Rule 15, that might suffice for providing notice and relation back. But Ellman, the very following sentence is that has nothing to do with service. And of course, what's at issue here is under Section 42-16209 service requirement. Additionally, the need to name the county as a proper defendant comes not exclusively from case law. It comes from Section 42-16208, which discusses who is a properly named party once it gets to the tax court. And so at that point, the properly named party is the county, and then the county under 209 must be named and served within 10 days of filing the appeal.
Here they were named. The question is whether they were not served.
Your Honor, they weren't named either in the initial what's called a petition. The only entity that was named was the assessor's office. And then there was no naming of the county until the amended petition or notice of appeal was filed in June 2016, and service was not affected. And I think it's also important to bear in mind that service in the context of 209 is rather easy. It's certified mail. It's also not as though the county's in hiding. Service is pretty easy on a government entity in this context, and they weren't served within 10 days. They weren't served until September 1st, and that is why the tax court indicated that excusable neglect did not exist under these circumstances. I should note that under Ellman, I'm not sure. Under Ellman, this court talked about giving considerable deference when it comes to making the tax court's decision on excusable neglect, because the tax court is immersed in tax cases and understands, I think it was called the general level of confusion among practitioners. And particularly in Ellman, dealing with the procedural requirements of tax appeals. And so in this case, the court found that there was no excusable neglect because analogizing the conduct of the attorneys here to cases that were 25, nearly 30 years old just didn't get them very far in front of the tax court. Even if, as has been pointed out, the case law discusses valuation or classification claims, there's nothing in the statutory scheme that would indicate they need to be treated differently than error correction claims. And as a further note, the issue of notice with regard to applying Section 42-16209 is in many ways a red herring, and it bleeds over from the issue of excusable neglect. Although I believe it's the Pima County case discusses that one of the historical antecedents to this 209 statute was a notice statute. That was in order to distinguish it as a notice or procedural statute from a jurisdictional statute. And the county's not arguing that failure to comply with 209 automatically means you're out of the tax court. Of course not. The tax court still has the discretion to extend it, and in this case, the tax court properly exercised its discretion not to. Unless you have any further questions, we would request that you affirm the tax court's decision because appellants failed to comply with Section 42-16209, and the tax court properly determined that there was no excusable neglect for that error.
Good. Any other questions? Thank you, counsel. You may
Thank
be
you.
seated. Ready when you are.
So I apologize if I misspoke with regard to my reference to Article 5 and what it does and does not say. The point that I was attempting to make is that Sections 202 to 206 set forth the appeals that can be made and should be made under Article 5, and they specifically refer to valuation and classification claims. And Article 6 similarly makes this distinction. So when appellants filed their complaint, they read the statute on its face and followed what was there in the statute. This is a case of excusable neglect. The law is extremely muddied in this area, and the tax court did in fact abuse its discretion by reviewing cases that didn't even consider what is the most central issue that we are discussing here today, which is whether or not there is a real distinction between tax rate claims and valuation and classification claims. And that's all I have for you. Thank you. Oh, and we request that this court, reverse the tax court's decision.
Counsel. We thank you both for your arguments. This matter will be taken under advisement, and we will issue a written opinion in due course. Thank you, counsel.